Welcome to another episode of the Legal Tumble podcast. I'm your host, as usual, Lucas Mwangi, and I'm here hanging out with the expert, our resident scholar, a small Daktari, Kenson Matavia. He can say hi to the listeners since we have been on a very semi-long hiatus.
We had gone on a long break,
Sabbatical.
on a sabbatical leave.
Anyway, now we are back.
Yeah, we are back with a bang.
Mhm.
We are bigger and better, I believe, and
Yes.
we can only now plan to give more and more.
Yeah, true.
Yes.
So today we are discussing the issues surrounding impeachment. Of course, our listeners, since they're keen and they're keen readers and viewers, they have been treated to a plethora of impeachment which have
Yeah.
happened in our country.
Yep.
So even from our previous episodes, we had been talking about the impeachment processes here and
Mhm.
there. So,
Yeah.
but I think today we can touch on them a bit, just
Yep.
as we ease into more issues that we'll be discussing in the future. So yeah, we have been having so many impeachments which have been happening, and of course the biggest impeachment was the one for the deputy president.
Yeah. The first
So
time.
yeah, the
Yeah.
the first one. So yeah, just talk
Yep.
to us about it. Yeah, like how quickly it was done, the court
Exactly.
processes. Yeah. So yeah, what were your thoughts on with this thing of the deputy president?
Well, first of all, the impeachment of the deputy president is a big thing. Is a huge thing. The
Yeah.
United States, which is technically one of the oldest democracies, it has only had three impeachments of presidents. In
Okay.
fact, I'm not quite sure whether there's been an impeachment of a vice president. And of all these three impeachments, none has ever been successful, really, because when you look at, I think it was John Adams, he was acquitted by the Senate. Trump was acquitted, who has been impeached twice, was acquitted twice by the Senate, and of course Richard Nixon, he resigned before, and of course we have Bill Clinton, who was also
Yeah.
acquitted. So basically four that were in time. Nixon was not impeached because he resigned before that could happen.
Yeah.
And now we come to Kenya, and it's basically like less than 15 years, less than
Yeah.
somewhat to do with 15 years since our presidency came into action, and we have impeached a deputy president,
Yeah.
and it is complete. He's gone home, and we have already replaced the deputy president, and we have
Mm.
a new deputy president. It was
Yes.
a monumental thing, basically.
Yeah.
As to put it quite simply, it was a
Yeah.
political process, and I think so that's one of the things we have been trying to grapple with in Kenya.
Yeah.
Since the advent of the 2010 constitution, there has been a very big question on whether now we can be speaking in Kenya purely political disputes and legal disputes. There seems to be a murky line on whether there is anything that can essentially be called a political dispute in Kenya that is not
But
available uh, for judicial review or for judicial scrutiny.
yeah.
Because ordinarily you'd think that an impeachment of a president, or the impeachment of any person who is subject to impeachment, basically is a job of the political branches. It's a political process. You've just mentioned that how rushed it was, which is basically the nature of political processes.
Yeah.
They don't lag. It is not in their tendency to lag or to take time, because they say usually a day in politics is
It's
long
like a
enough.
year.
It's
Yeah.
like a year. so much can happen within that
Yeah.
time, and you don't want to create that scenario of things.
Basically, politicians want to strike it while it's hot.
Exactly. They want to strike it while it's hot because they don't know what could happen.
Yeah.
It's a matter of alliances.
Yeah.
Alliances change every other time. And if you want to know how political it is, since that impeachment thing happened, there's been a lot of talk about it, both from the president, who was just recently speaking about the impeachment itself during
Mm.
the Sagana State Lodge talk. And
Mm.
Rigathi Gachagua, I think he replied to those allegations that were made there. One of the things that I found interesting was this president saying that the reasons why the deputy president was impeached, part of it was that he was blackmailing the president to give him 10 billion shillings, and failure to which then he would make him a one-term president. It was also, there were the allegations of that Rigathi Gachagua had threatened the MPs to kneel before him before December of last year, and the
Yeah.
failure to which that he would show them yeye ni nani. And
Yeah.
basically that's the issue, that if at all those were the issues that the president was saying that they caused, if you look at the impeachment motion that was presented before parliament, it
Yes.
was different from what the president was suggesting were the reasons why the deputy president was impeached.
Yes, of course, that shows us there is always the political push, and
Exactly.
then now you have like
Exactly, and there
the
is something
legal
that
front
is
that
the
now,
legal process, and basically,
yeah,
I mean, we have been involved in a number of impeachments, and we know very well that lawyers are just a sideshow in the bigger picture. We're just there to move the wheels, you know.
okay,
There's sometimes you'll have a very strong case for impeaching someone. It has happened to us very many times. We have a very strong case that you want to impeach an office holder, but because the politics of the day are not aligning with the removal of this person, is not going to be, he or she is not going to be removed from office. And that
mm,
sometimes, to the eyes of an outsider, it might seem that the grounds are not very solid,
yeah,
but they still get removed from office
yeah,
because the politics of the day are that that person should leave office.
okay,
And this is virtually connected to the constitution. If you look at our constitution, Article 145 of the constitution is what sets out the grounds of impeachment. It
Article one,
uses very interesting words to describe such a phenomenon thing. It says that a president will be impeached for gross misconduct, for gross violation of the constitution, and high crimes, both under national and international law. The aspect of the crime seems much pretty straightforward. You can know when a crime has been committed,
been committed, yeah,
standards to test that. But when it comes to these two other aspects, of the aspect of gross
gross
violation of the
violation,
constitution and gross misconduct, that is where now the trouble begins. That is where
okay,
now politics and the law weave.
yes. Now,
And
after
mm,
now you have set us a very good background, yes.
yes,
So right now, we are now launching into this other aspect of how the law and the judicial processes now
mm,
intermingle or interact with the political process or
yes,
interact with the whole process of impeachment. There's
yes.
this there's this term that I had read on or had seen, I came across the issue of the judicialization of
Mm-hmm.
politics.
Yeah,
This is where now the issue of judicialization of politics now comes in.
absolutely.
On the issue of, as you were saying, the issue of the gross violation of the constitution,
Yeah.
the courts now have to now come in and ask themselves, are these grounds,
Mm.
do they suffice? Do they suffice? Can you
They
speak
mean
more
the
into this
threshold.
issue, the threshold? What is the threshold for an
Yeah.
impeachment? that what have the court said about this issue?
Yes. I mean, if you look at, I will want to start from that aspect of judicialization of politics, really. And that's why I started by talking about the aspect of how, in the post 2010 constitutional dispensation, there seems to be a very thin line between political issues and legal issues,
Yes.
such that there is no clear line where you can say this is a purely political matter, and so the judiciary should completely keep off from that particular aspect. Article 165(3)(d) of the Constitution grants the High Court a very peculiar jurisdiction. It says that the High Court has jurisdiction to review whether anything said to be done under the Constitution has been done in accordance with that Constitution. So basically, it is saying that the High Court has jurisdiction to test anything that has been done under the Constitution. And then the first question then becomes impeachment. Impeachment is a function that has been delegated to Parliament or to the county assemblies through now operationalization of Article 181 in the case of county assemblies to constitutional bodies. And so the argument basically will always be said the impeachment process is something done under the Constitution, and therefore you cannot run away from the court reviewing that. That's number one aspect. Number two, you have already said that we are having very fascinating terms that have been used here for the purposes of impeachment. We're saying that there is a gross violation, there is a gross misconduct. The Constitution, Article 259 and Article 260, which provides for definitions, do not give us the definition of those two terms. If you go to the Statute of General Interpretation, it does not give us those definition of those words. But what does the Constitution say again? We go back to Article 165 3D, 3D, which also again gives us and tells us if you have any question about the interpretation of this Constitution, where do you go? Go to the High Court. So that now the question of what amounts to gross misconduct, what amounts to gross violation, has been subjected to judicial interpretation. Luckily for us, I think we are very excited to test this Constitution.
Yes.
When the first devolved government came into office, that is sometimes in 2013, immediately less than a year, by January of 2014, there was an impeachment of a governor, Wambora. And that was the biggest question that was there now. The governor was to be impeached because of some procurement processes that had gone wrong. There was some there were some maize seeds that were procured. They were sold to farmers. They did not mature as they were supposed to. There was a stadium that was supposed to be refurbished and done all those manner of sort of things that did not come out very well, and what have you. An impeachment was presented to impeach this governor. And Senate, the county assembly, impeached. I know you will want us to talk about the aspect of conservatory orders, which was a very huge thing that happened in this case of Martin Wambora. But for the purpose of this discussion of what we have asked, is that an impeachment was presented, and it was said that the governor had grossly violated the Constitution and the law, and an abuse of office because of these two procurement processes. The first impeachment was not successful because the High Court quashed it because of Conservatory Orders, which is a discussion we're going to discuss a little bit later. But the same motion was reproduced back in both the County Assembly and the Senate adopted it. And then the question went to the High Court and the Court of Appeal, and the question was, what is this gross violation? Number one. Number two, what is the standard that should be discharged so that we can say that it can? For lawyers, we understand that there is a balance of probabilities, there is an intermediate, and there is a reasonable, beyond a reasonable doubt. And the question that was presented was, should it be on a balance of probability? Should it be in an intermediate level, or should it be beyond a reasonable doubt? And the courts were emphatic, and this is the Court of Appeal and the High Court, of course. They were saying that what we need to be doing here is that we need a nexus. So they introduced that word of a nexus. There is a wrongdoing on one part, and there is a person on this other part with the office holder.
Yes.
What they have done, let us ask ourselves, first of all, is there a connection between the two of them? And that is what now they are calling nexus. There must be a nexus between the violation and the person. Once you do that a nexus, it is not every wrongdoing. And that's now they use now lexicon languages. They say that gross word has not been put there by mistake. It is not cosmetic. It has an implication. It has seriousness. And they try to say that this word gross should be given serious definition. Whatever is gross is something they use the word appalling. It must be shaking.
Yes.
It must be something that is shocking. It must be something that if I was just walking along the road and I'm not supposed to be eavesdropping the conversation of two people who are having a normal conversation, but once I hear what they're talking about, it attracts my attention.
Yes.
And they're saying now, this is gross. Something that is appalling, something that is humongous, something that is shaking, something that is not ordinarily wrong, something that you would not want to sit insofar as accountability is concerned. And now this is where now they introduce the other aspect. They're saying it is something that is appalling, not beyond a reasonable doubt, and not again on a balance of probabilities, but just in between.
Intermediate.
If you are to put it in mathematical sense, balance of probability means a 50% plus 1.
Yes, 50 plus 1.
It is just there, and we just add something that tilts the balance in favor of one side. That is what a balance of probability is. Beyond a reasonable doubt is almost 99%. There is no opportunity that something else in the alternative is more profound than whatever is being alleged. But when you're talking about an intermediate, or what we would call sometimes a preponderance of evidence, it is something that is now in between. You can talk about 53% all the way to someone to do with 89. It's just there, something that is just transcending the balance. So that now the courts have told us, and of course even the Sonko decision in the Supreme Court was just building on what the Wambora decision was saying, is that once we show this nexus, once we show that is something that is appalling, and once we show that is something that is just not basic as usual, because the Court of Appeal again was saying that if again we want to make it very easy, we are not going to have anyone in office, because we are going to have any sort of misdoings being brought for impeachment purposes and what have you. So that now they say that you just need to substantiate. There is an allegation, so long as that allegation is substantiated, and a substantiation is a little bit less than proving something beyond a reasonable doubt. Just make it make sense. Make it make sense, and we'll be able to move along with that. There was some bit of problematic in terms of how the Court of Appeal was handling that Wambora aspect, because you're saying that if you look at procurement processes, for instance, the governor is not the accounting officer of the county. And they're not going to be directly involved.
Exactly.
And so the Court of Appeal was asking the question of how then are we going to say that a governor has violated procurement processes,
Yeah.
yet they are not in charge of the procurement processes?
Actually, that is what I was thinking about because it also brought to mind this issue, especially now in light of the whole YT2 case of
Yes,
sentencing of the governor. If
yes,
they are just mere allegations that this person has created funds, but
yes,
they use proxies, they use other people. So if those are the only if that is the only basis for the impeachment, how then will
yes.
you satisfy this threshold? Because if the courts go into looking at that, you see they will get themselves into some murky waters
In
because
some
how
market
do
waters
you
that they don't want
yeah
to get themselves into.
yeah so
And that's why basically the whole idea is that courts should have a very differential attitude towards impeachment proceedings
yes
and defer to the decision that has been made by parliament. Because if you look at the arguments that senate and I think were making in the Wambora case, they're saying is the overall in charge, and you don't want to get into these nitty gritties of showing
yes
how exactly he was involved,
yeah
because for us we are talking about accountability. Remember, at the end of the day, impeachment is about accountability processes.
yes
It is not about going into the nitty gritties. If it was a criminal case that was saying that he was involved, much better. And it's also it is suited for courts to be going into that process and to be able to interrogate and to intervene and say yeah. But it is possible actually that the governor may not be involved in these procurement processes, but he holds the ultimate responsibility of ensuring things are running along in the um, in the county government. Now that is not an argument that might be acceptable to everyone, but the fact that it is an argument that might be fronted, I think for me it is an argument that is better argued in parliament more than in courts, because then
yes
courts are put in a very delicate position of
yes
determining should they go this particular way of saying yeah, it doesn't matter whether you're directly involved, there is some sort of responsibility on your part, no it doesn't matter, and what have you, and then it will be taking away the authority
yeah
that has been vested on the legislative bodies that have been given the power to impeach, and then it will be the courts now. You remember what MPs have done when it comes to recall process? They were saying if you want to recall an MP, go to court first and ask the court whether the grounds that you want to recall an MP are serious grounds.
yes
Once you get a
yes
judgment that approves, now you can come and start. Basically,
yes
they were giving the courts the power to recall
yeah
MPs in that process, because it is the courts to decide that this is a substantial reason for removing someone in court and in office and what have you. And the most interesting bit, of course, was that they were virtually almost the same grounds that a governor would be impeached for. And now these
yeah
ones, they are saying that go to court first and get a judgment that says this is a valid ground for recall and then come back to it. And for me,
yeah
I think that it is not appropriate to invite
no
court into that arena.
okay, it's not. Yes, we agree that it is not appropriate, and actually, the action of the MPs shows
Mm,
us that for them they have already seen the bigger picture of the game because
yeah,
they have already seen that for you to make this argument of substantiating grounds, you
it's
have to
very
have
high.
like an empirical proof. Like you have to say this guy
Yes,
or this person
which is
has
very
been
difficult.
convicted, which is very difficult. And if the reason why MPs are sending their people, their constituents to court is because
Yes,
you have to go to court to prove these grounds. And even if you
exactly,
were to prove them, they would appeal that decision. So they will
exactly.
still keep you in the courts until. So in essence,
Yeah,
it's just proving your point. And also just to circle back to whatever
yeah,
to your beginning point is that if courts go into asking themselves whether the grounds are substantiated, yes,
yeah.
and if they say these grounds are substantiated, what if, as now has happened, the president now comes and says, actually, this is the reason why we impeach this guy or we impeach this person.
Yeah,
It's not actually these other legal reasons that we
yes,
fronted.
forget
You're,
about
you're
those.
left in an awkward position.
Yeah.
Yeah. So I
I mean,
think, as you were saying, yeah.
it's what the whole question. I've been saying, I've been grappling with a very huge problem in this country, that all arguments that have been given by against the political questions doctrine, both by several practitioners and judges alike on the bench, are very lazy and unappealing arguments. Really speaking, one of the
Okay,
aspects.
just to pause a bit,
Yeah,
since we are now throwing a lot of doctrine, just to put like what should you say, like a general overview. What do we mean when we're talking about the political question doctrine? So that now we can go
absolutely, and that's
into
what actually I
conservatism.
wanted to drive into it. The political questions doctrine is basically a doctrine that basically asks courts to step back a little,
Mm,
to ask themselves what is the nature of the dispute, or what is the nature of the matter that is before us. Is it appropriate for us to interrogate this dispute, or is it not appropriate for us to interrogate this dispute? If it comes to the conclusion that this is a dispute that is better resolved by other constitutional bodies such as the legislature and the executive, then it invokes the political question doctrine and says that we are not going to interfere. It's basically a judicial restraint. Uh, uh, it's a judicial restraint principle, and it
mm,
forms part of the doctrines of justiciability. And justiciability is basically things that are subject for judicial determination. So and now my argument basically was, we have a very lazy arguments against the application of the political questions doctrine in Kenya, because everyone who argues against this political questions doctrine is arguing in the line of judicial absconding. They see it as an absconding of judicial duty by courts once it is invoked always.
mm,
And for me, I think it is a very lazy argument, because there are very different aspects of the political questions doctrine, and one of them is that it is very important, and especially for the purposes of the Constitution of Kenya 2010. Remember, we started by saying that the Constitution is saying that anything that is said to be done in the Constitution is subject to judicial review. Okay?
yes.
And they're saying that impeachment is one of the processes that is done under the Constitution. So you cannot legitimately say that the courts do not have jurisdiction. But there is a
Mm,
notion that has been sold in the Kenyan judicial spaces these days and the legal spaces these days to equate jurisdiction and justiciability as one and the same thing. And basically, the argument that I've been trying to front is that the applicability of the political concerns doctrine in Kenya today does not operate as a battle jurisdiction, but it operates as a judicial restraint aspect, in which
mm,
that contrary to this assumption that the political questions will typically remove impeachment from review by courts, it actually just tells the court, look at this whole aspect, and it brings the aspect that you're saying. Now, if you look at this question of Rigathi Gachagua, assuming the grounds actually do not meet judicial tick, okay,
yes.
who will Gachagua go back to work with? The president is saying he was already telling the MPs that they have to kneel before him, and they refused, and that is actually why they impeached him.
Yes.
Technically speaking, actually, this is the exact thing that we had intended to bring as an impeachment process. Actually, that alone is a very proper ground of impeachment.
Yes.
Trying to show, trying to square out with another political lineage and what have you. It is abuse of office. You're
It's
basically
abuse of
abusing
office.
your office, and you should go home. Now, assuming the courts disagree, it is what we call that this is a non-maintainable judicial order. It will be like an order. You see, I remember one time I asked my criminal litigation lecturer, why don't we have an order that can compel the DPP to prosecute a case, and the only alternative that we have under the law is private prosecution, where the DPP has refused to charge someone, you can go and do private prosecution. And he asked me and responded me a question telling me that if a husband and wife are having some troubles and one of them goes to court for a conjugal rights order, you might get it. But what will happen? Will the court come to ensure that the order is going to be enforced and what have you? That is the whole aspect of the political questions doctrine in this aspect. That courts should be able to ask themselves, what is the practical effects and impact of their judgment? Because courts are actually prohibited by the very nature of their work from giving orders that are in effect itule, that do not have any practical consequence. It is an abuse of judicial authority. Now, courts know that there is a political bad blood between these two guys, and then a court gives an order reinstating that person to office. You can imagine how much of a problem that would occasion. And that's basically is another aspect of this political questions doctrine. Yes, it is not about to jurisdiction, but there's some disputes that even if the court has jurisdiction, it may choose not to entertain them in the first place because there is no known or recognizable judicial remedy that can be given or maintainable, unless of course there are issues that have been raised regarding fair process and what have you, which there can be other remedies other than the ultimate aspect of quashing an impeachment.
Yes, I can see the nexus. You see, as you were saying, as you cycle back to whatever we said before, is that nexus between the political question doctrine and of course how it affects the judicial restraint and how it affects the whole impeachment process and of course the judicialization of politics. They all have a big nexus. They all come together. And where they come to a head is now on this issue of conservatory orders because yes, as you were saying, the bad blood does not develop in a day or is not something you always hear it in the grapevine, you always see it in the news, you will always hear the rumors. This person is going to be impeached, this person
it will predate the legal process.
Yes, it always predates. You will always see the rhetoric on TV. These guys are starting to talk about this person, we are going to do this, we are going to do this. So before or maybe just before or just when it commences, the person who is involved, who is being impeached, usually will run to court and to seek this remedy of conservatory orders. And as you are saying, there's this interplay of the issue of judicial restraint, where we must say court, there is that the doctrine of equity where the court should not act in vain, but vis-a-vis but the other aspect that the court has jurisdiction, and there's also this other doctrine of equity. Let justice be even if the sky falls. So in the issue of conservatory orders, now how are we supposed to see, or how are we supposed to treat conservatory orders in this case of impeachment?
Conservatory orders is something that has always been there. I mean, even you or even me, or if my client was to be impeached, the first order of business basically is to try and obtain a conservatory order trying to stop it. I think the only person in the recent past who has never done that when they were impeached from office or they were trying to be impeached from office is Linturi. When Linturi was being impeached, he never went to court to seek a conservatory order to stop Parliament from processing his impeachment. But from the very first impeachment motion, that is the impeachment of Wambora, he rushed to court and was saying that I have not been served with the motion of impeachment or the grounds which they intend to bring to remove me from office. Please give me a conservatory order that stops them from impeaching me until they give me the grounds of impeachment so that at least I can be able to defend myself. Remember that time there was actually no known procedure of how things should be done. It was the very first impeachment. This guy was never even invited in the county assembly to defend himself. The first time, in fact, the first time he was seeing the grounds of his impeachment were in Senate. And of course, he was granted the Conservatory Orders. And of course, there it seemed to make a little bit of sense that before you impeach someone from office, give them at least the benefit of seeing why they're being impeached from office, and so allow them. So a conservatory order, simply speaking, is a temporary reprieve and a temporary stop or halt of a impeachment process until something is done that is supposed to safeguard the rights of a person. Article 22 and Article 23 of the Constitution are saying that where there is a threat, the Constitution right now expanded the issue of the jurisdiction of court. You don't have to wait for something to happen. Unaona venye hii mambo inaelekea hapa, my rights are going to be violated in the process. So I don't need to wait. Let me go to court and obtain something that will ensure my rights are not violated. That was the original view of why someone would seek conservatory orders, is that you want something to be done so that you can ensure the process is done. But obviously, that is not the reason why people are going to seek conservatory orders these days. They're just going to frustrate the process. That if I just put an alt to it, I can be able to pull some antics here and there, or just make it go and die itself. The High Court in the Wambora case granted him that conservatory order. And actually, the granting of that conservatory order and the proceeding of the impeachment, despite that conservatory order, was the foundation of the High Court and the Court of Appeal setting aside the first impeachment of Governor Wambora. They said that he should not have been impeached. But quite interestingly, I always get the impression that it is either courts do not read the Supreme Court decision in the Wambora case, or they deliberately ignore it. Because this is what the Supreme Court said in the Justice Mate Kariuki case. It was saying that actually conservatory orders should not in any case be deployed against a constitutional process. And if you deploy them, the county assembly and the Senate are actually under no obligation to obey them, because they should not have been issued in the first place. You remember that what happened in the Justice Kariuki matter. Remember, now we have said that the High Court actually quashed the impeachment of Wambora because the bodies proceeded despite this court order.
Yes, conservatory.
Now they made an application for contempt of court, and actually they were found guilty.
Yeah.
And they were about to be sentenced. And Justice Kariuki Mate appealed to the Court of Appeal. And the Court of Appeal agreed with the High Court. No, you guys are going to punish you for contempt of court. There was a court order that was given, and you did not obey it. You should be punished. Then the matter went to the Supreme Court. Justice Kariuki Mate now goes to the Supreme Court and says, look, these orders were meant to stop a constitutional process from going on. I don't think they were legitimate orders. They should not have been issued in the first place, so I should not be punished for that. And the Supreme Court agrees with Justice Kariuki Mate. He says, no, you should not issue conservatory orders whose effect is to derail or to frustrate a constitutional process. I think it's a pretty much problematic position that was given by the Supreme Court. Because from where I stand, if there was any time conservatory orders were genuinely deserved, it is the Wambora case. This guy has not been served with the articles of impeachment. He doesn't even know. He's only going to find out at the Senate. Surely decency only demands that gives this guy, it usually says that even the devil himself should be given an opportunity to defend himself, and no person should be condemned and hurt. But this is what the Supreme Court says. The Supreme Court has never departed from that judgment. And of course, I think I was posting on Twitter the other day the irony of that it is the Supreme Court judges who have now gone to seek conservatory orders
against the constitutional
against a
process.
constitutional body, when it is them who have said that no constitutional body should be stopped from discharging its mandate. Of course, again, the Court of Appeal restated the same process by the Supreme Court in the Kawera Mongaza case, and basically the ultimate ground of the court that has generally been, let's allow these bodies to do their work. If they violated your rights, let's do the style of Wambora and quash the impeachment because it violated your rights. You can always come back to court much later on. But I think the problem for me is how the Supreme Court, I think you remember there is a case you were showing me just a few minutes before we started this discussion of when we were saying that the overt constitutional violations, I think they should be stopped. Something that is so patently unconstitutional, just give them a patch to regularize. For instance, the conservatory order that was given in Wambora case made a lot of sense. The conservatory order was basically saying, we are only stopping this until you serve. If you serve him with that cause of impeachment and he knows what he's being impeached with, you guys proceed. No one is going to stop you. And they never did that in the first place, and what have you. And basically, to that extent, then I will agree that conservatory orders may be issued in that circumstances. But if there is no obvious or overt constitutional violation where it can be clearly seen that the purpose of this conservatory order is basically to derail and to frustrate this process, then it should just wait until the process is completed by the final constitutional body, and then you can go and level out those matters in court.
Yeah, I think also, I think that Supreme Court ruling or the Supreme Court judgment in the matter case is actually a good ground for the courts to be exercising judicial restraint in matters. They can be using that as their crutch to exercise judicial restraint.
Absolutely.
However, and also now on the issue of conservatory orders, on the issue of overtness of the constitutional violation, I think yes, the courts have said yes, it should be rightly stopped if there is an overt constitutional the violation of the constitution against the person who is being impeached. So yeah, I agree with that, but yeah, I sometimes also it brings the question, what is actually overt? In our constitution that has a plethora of rights.
The Supreme Court was avoiding in Justice Kariuki Mate, because in Justice Kariuki Mate they're saying under no circumstances.
Yeah, because our constitution has so many
something
rights
that should be dealt with.
Yeah.
After the process.
Yes. There is that balance. Now the courts have been saying that let the impeachment process proceed to its logical conclusion, then come back now and seek the reliefs, not before. Because as you're saying, there is a lot of misuse. There's a lot of cat and mouse games that is being played in this issue of impeachment.
Absolutely.
And using that leeway of conservatory orders. And as we just talking about conservatory orders, there is that issue of conservatory orders going too far in kind of being a merit review of the impeachment itself. So what is the balance? What is this overtness, and how do the courts balance between that and not going into merit review?
Well, sometimes conservatory orders can be deployed in such a manner that they basically foreshadow the outcome of the impeachment, or they are final in nature. They predetermine. They predetermine the impeachment process and what have you. Number two, what they always do is that they are always open-ended, and they are not a very specific, and they are unlikely to be like the conservatory orders that Wambora had been given. I always use those as a very good example because to me they made a lot of sense, that they were saying just serve it. The purpose of this
Yeah.
conservatory order is just to serve it. Now, it is quite different from the conservatory orders that, let's say, Kawera Mongazu was seeking, or
Yeah.
Rigathi Gachagua was seeking. For instance,
Yeah.
if Rigathi Gachagua was ever given the conservatory orders that he was seeking, it would be basically foreshadowing and foredooming the impeachment motion. It would be
Yeah.
predeterminative of the impeachment motion, because he was not giving any valid reasons such as these ones, because he was
Yeah.
given notice of the impeachment. He was
Mm.
just saying that, oh, there is a rush.
The,
I think they
there's a
think they
rush.
know what they are doing. You're saying that it is a
Yes.
predetermined outcome. That's why they are rushing. And I think it could have been so inappropriate for any court to have granted conservatory orders stopping the impeachment of Rigathi Gachagua, because then at that time it could have been foreshadowing the
Mm.
outcome of that impeachment, because it was not in any way based on the procedural aspects of the impeachment itself. So if you
Yeah.
use that example and the Wambora case, we can probably try to show the difference or how to strike a balance. Let's just
Yeah.
ask, which one is completely procedural? I
Yes.
think I did not see that one, that way Guru case. Read it, but I saw it somewhere being suggested that it was in the middle of COVID-19, and I remember
Yes.
actually the
Yes.
impeachment of Waiguru happened during the COVID-19 pandemic, and there was a
Yes.
question of, it was when it was in the early stages of COVID-19, and we did not know how
Yeah.
to handle this and what have you. Was it to be in person and what have you?
Yes.
If there is a lockdown and it is only MPs who can be able to move around, and probably Waiguru could not come out together with a legal team and be able, I think that would be somewhat a good ground to grant a conservatory order, because it is independent of the impeachment motion. It is factors that are completely procedural in nature. It is about how we process this impeachment. She's just saying that because of this pandemic, I'm unlikely
To
uh,
obtain a fair hearing.
to obtain a fair hearing in the circumstances. But
Yes.
then I would only think of these conservatory orders to be genuine and to be in the best interest of justice if they are within certain boundaries. They're
Yes.
saying that we are going to give this particular number of days, let's say 3 days, 5 days, 4 days, and what have you, so that this can be done and what have you, so that it is again not open ended. Because if you have seen the nature of conservatory orders in Kenya and how they have always been abused, not
Yeah.
only conservatory orders, is that someone obtains ex parte orders and keeps on extending them to no particular end. And so
The
therefore,
language used is saying these
yeah,
orders are
exactly.
granted until the hearing and determination of this
Absolutely,
application.
absolutely. Making them basically, and what happens is that you get a Pyrrhic victory if you
Yes.
set them aside. By the
Yes.
time, by the time they are set aside, whatever
Yes.
you wanted to set aside them for is already
Yes.
overtaken by events and
The event.
what have you.
Mm.
Absolutely, the safest pattern is to say, let them choose their path. The latter is the legislative bodies. Let them
Yeah.
choose either to follow the law, in which case the impeachment is unlikely to be disturbed, or they do whatever they got to do, as although it's a very time bound process,
It is.
and then you will come to court and then we are going to help you. But of course you see that there are so many human rights activists in our dispensation right now are saying, no, 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 but the constitution already knew something like that would happen. That's why they
Mm.
said that if there is a threat to a violation, you don't have to wait for it. So they will be
Yes.
telling you, so you want to tell me I should wait until something happens and so that I can come? Why don't I just stop it? But you see, when you're looking into the aspect of activism, sometimes it doesn't want to sit very well with pragmatism, because this
Yes.
one is not like you're going to be condemned to live with that illegality. We're just telling you
Mm.
it might be a need to give you recourse right now. And after all, even if we give you these recourse, these guys will still proceed to with this these better orders. Why don't we
Mm.
just wait until when now it is completely in our hands.
Mm.
They have already completed their process. There is nothing more they can do. If we say you go back to office, they can only prevent you from going back to office through their political means, but legally you should go back. And if your only concern was probably salary and what have you, you'd be able to get all those things and what have you at the end of the day. So it makes much sense to wait it until the end of the process, until, or except for me that I have certain exceptions that I can make. That there's some
Yeah.
instances which are too obvious for me, why we don't have to wait until such a time. But even for those obvious instances, let us have very time bound and time specific conservatory orders, and
Yeah.
not open ended and vague conservatory orders.
Yeah. I can see what like I see the kind of, what should you say, like the conclusion, and what you're coming to is like the aspect of judicial restraint
Yes,
actually enables a matter to come to it, to become ripe, to become justiciable in the end. Because
absolutely.
if we do not exercise this restraint, then the
Yes,
matter starts wobbly, starts becoming wobbly, and it starts having so many issues with it. Because, for example, if you issue conservatory orders in their nature have that aspect of giving, well, it gives an incentive for
incentive to
the parties
derail.
who have to derail the matter. And as you had
Yeah,
seen in the Rigathi Gachagua court case, the
yeah,
lawyers had, because when they sense they have a kind of an upper hand,
yeah.
they were doing what maybe in America is filibustering. They take their
Yes,
time they
exactly.
take their time to argue their points so that the
They
matter
come
can
with so
drag out
many
for a
other
while.
ancillary issues, applications,
Yes, until
recuse
yes,
yourselves
yes,
so that they
yes,
can
to,
continue enjoying the orders.
yes, yeah. So I think that's the code. That's where you're driving at. That judicial restraint actually enables the matter
Protects the
to,
judiciary from abuse.
yes, yes, and actually gives actually substantive justice.
It gives substantive justice and it prepares the judiciary until it has judicially maintainable standards
Mm,
in which now they can be able to adjudicate the matter and give
mm,
a solution that actually is able to remedy. Because
okay.
again, you
Mm,
should never give a remedy that is unable to
mm,
deliver justice to the person that you're giving something. It would be
yeah.
very unfortunate in the circumstances of any particular case to do do that.
Okay, I think now we are saying in this, yeah, we are the judiciary should be very, very watchful and
Yeah,
should be very on guard when it's dealing with impeachment cases. And
yeah,
I think today it's not the actual end of us talking about impeachment. There's so many aspects we can talk about on impeachment.
absolutely. There's a
We are just
lot.
scratching the surface because
Yeah.
we have not touched on so many issues.
I
But
mean, we've
I
become
think,
a very impeaching society, and from the look of things, impeachment are not any time likely
yeah,
to
they're not
end,
ending. Yeah, they're not ending anytime soon.
and a lot needs to be done.
Yeah.
Insofar as that, I think it's about time we have reached where we can settle the jurisprudence on impeachment. We have far too many
Mm,
examples and scenarios that have happened that can be used to come up with both legislative and judicial standards for dealing with
okay.
impeachments.
Yes.
Yeah.
Yeah. I think you're right on that issue, and that we have a lot of, in the 15 years our constitution has been in existence.
Yeah.
We have had so many impeachments.
So many.
So it's already, the system has been tested, and now we can settle into something, and maybe we can start having a discussion on the way forward from there.
Absolutely.
So yeah, that has been a good discussion. Thank you so much, Kenson. I
Yeah.
think that was very informative, even for me, and even
Yes.
for, I hope also for our listeners. And
Absolutely.
we endeavor to keep on giving them at least some entertainment and legal entertainment
That is
and
our
good
hope.
information. Yeah,
Legal
that's our hope.
nourishment and entertainment at the same time.
Yes, that's our
informative,
hope.
and entertaining.
Yes. So thank you so much. I think we wish our our viewers the best of luck, and we'll see them